All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for an early edition of Fire Law Roundup. We're doing it on Sunday instead of Monday, but this is the vlog for October 6th of 2025. Brad, go ahead. Take us away.
Today's theme, if there is one, is just this stuff is weird. I mean, that's all I can come up with. There's some interesting stuff. So a couple of weeks ago, we're going to start in Youngstown, Ohio, which yeah, right where their good friend Chip Comstock is. And I wonder if he knows people. But a couple of weeks ago, we had a defamation case where firefighters were suing for defamation, and we both said like this is novel. This isn't going to be the last. It's very hard to win a defamation suit. And it wasn't the last because now in Youngstown, we've got two fire captains who are suing the mayor. I thought it would have also been the fire chief, but the mayor. And basically, what they said is they had a meeting, and a couple people were in the meeting. One of the law director, I guess, left the room to take a phone call, and then and I should say that the firefighters were there, I think, in their capacity as union reps, the union president or something, right?
Right.
And which does change, importantly, the facts a little bit, but the and I'm just reading what's alleged to have been said. This is just a lawsuit, not a court finding, but they allege that the chief exhibited signs of anger and vitriol towards plaintiffs, saying, "You are punk ass white boys and little white bitches." Hopefully, YouTube doesn't mind me saying this. And he says, allegedly said, "I'm tired of you white boys." Now, the chief is black, I believe. And the chief allegedly accused the two plaintiffs of being racist towards him, and allegedly said later, and I think they claim he recalled saying this: "I am so tired of you white boys constantly coming after me for no reason, and it just never stops." And when the plaintiffs allegedly, I can't keep saying that enough, told the chief, "Look, we're not racist," the alleged response was, "You know who always says that? A racist." So look, we don't know, but here's what happens right after that: that there's a number of disparaging remarks then published in the paper, characterizing, as they claim, characterizing them as racist, portraying them as the aggressors while depicting the chief as the victim. My question is, how did this even go from a private meeting to right in the newspapers? But in any event, they've sued for defamation, claiming harm to their reputation, professional relationships, public hatred, contempt, ridicule, shame. I mean, if it's true, I don't blame them.
Yeah, when I looked at it, I'm looking at it more from I think a little more labor perspective. And one of the things that if they were in fact there as union reps, and this could be construed as an unfair labor practice because this is something that could
Interesting.
potentially go in that direction. So there could be some labor related uh, issues that go to that. And, management is trying to drive a wedge between the president, vice president, and the membership. I'm assuming many of whom are minority firefighters. And so trying to drive a wedge there. So that could be an unfair labor practice, and there could be some consequences there. But whenever you're in that realm, there's and I'm surprised we didn't see it here, is this race discrimination. And it'd be a reverse discrimination claim. And then, whether that is strictly, going to be a Title VII claim, or whether they could turn into a constitutional claim, and that they were there advocating on behalf of the union, which is a First Amendment issue, and their objections to maybe some what the chief was doing is protected by the right to the freedom of association embodied in the First Amendment.
Wow.
So I think, and
Their lawyer should pay attention to what you're saying, because I don't
well,
think he's thought of three quarters what you just
yeah,
said.
no, I get it. But I think here's the thing, and this is where each attorney, like sometimes you just want to focus everyone's attention on the most prominent claim that you have. And yes, we could allege this. Yes, we could allege this, but the defamation is the probably the prevailing claim. So you know what? Let's make it simple for the court. Let's just go with defamation. That may be what the attorney's thinking, you know. And there's two schools of thought. One is the shotgun approach, where you hit them with everything, and the other is no, we're going to go narrowly, and we're just going to focus on this one thing. Yes, we could allege an unfair labor practice and maybe a First Amendment, maybe a Title VII claim, but we're going to stick with the one.
But I like it because, you know, you have to claim malice in defamation, right?
Yeah.
There needs to be some malice. And
It's a
the
high
motive
bar.
for malice, you would have just come up with driving a wedge between, right, the two races in the union.
Oh yeah, well they apparently got voted out or they stepped down or whatever, but this led to them no longer being the president and vice president. So
It'll be interesting to see the answer, to see the response, what they say. Like, yes, that's true, but here's what they said to me, or whatever. I mean, who knows?
yeah.
So, all right. So the next one I want to go out on a limb and predict they lose. But and they're going to lose. Here's what's going to happen. Then I'm going to explain why I'm saying this. And I'm not even telling the facts yet, but the defendant, the fire department's going to file a motion to dismiss,
Yep.
and then they're going to move to amend the complaint. And here's why I say that. So here's what it is, and then here's I'm shocked that somebody filed a lawsuit like this. But so we have a family of fire captain. The captain had difficulty breathing. He was on duty at the firehouse in October of 24, so a year ago. He began exhibiting seizure-like symptoms, allegedly. Now, this is just a lawsuit. Crews placed him on a monitor, showed a cardiac dysrhythmia, and then he goes into cardiac arrest. They intubate him, right? So this is a witnessed arrest. Usually we have an issue of proximate cause, like, oh, you can't prove it because he's been down a long time. None of that's going to be an issue here, but I'll tell you what the issue is going to be. So they tubed him, but they allegedly did not get his lungs, and they're bagging him for 45 minutes, and apparently, he's hypoxic for 45 minutes. So I want us to take a break for a second, or pause for a second, let everyone understand some standard of care concepts, right? Because we always do this as in education for everybody, not just updates. And in every lawsuit, there needs to be pled a standard of care: negligence, gross negligence, recklessness, or something sometimes called willful or wanton conduct, or intentional. And it matters what you plead, because in many states, like California, I'll cite everyone the law, in many states, firefighters and EMTs are not liable for ordinary negligence. And ordinary negligence is the failure to act like a reasonable EMT. And in California, I looked it up, that the Health and Safety Code, Chapter 9, Section 1799.106, and it says that EMTs and firefighters cannot be liable unless they were grossly negligent. Now, gross negligence is a tough standard. Mm-hmm. Gross negligence is not that you just failed to act like an ordinary EMT. Gross negligence generally is that you did not even attempt to act like an ordinary EMT. And by intubating him, and arguably, and I bet you'll see in the defense, arguably this was very emotional. This is one of their own, right? They probably want to get him to the hospital quickly. Maybe they're not thinking straight, but they were, and it's funny, I use this example, and I've used this example for 30 years, the difference between, well, you close your eyes and you try, didn't even try to intubate carefully. That might be negligence. But when you did try to intubate carefully and you just didn't maybe auscultate, or you thought you heard it, or you didn't notice a distended stomach, after 45 minutes of bagging, you would notice a distended stomach, right?
I think so. Yeah.
Yeah. So, but nonetheless, they have to prove gross negligence. But here's the thing. The fire department inevitably is going to make a motion to dismiss. Why? Because they only pled negligence. I looked at the complaint, and the big first line, they plead ordinary negligence. And the lawyer, you messed up big time. Now, what probably will happen is they'll make a motion to dismiss, saying, well, you didn't plead gross negligence under 1799.106. And then they'll say, well, you still have time to amend. So they amend. Maybe they have time, maybe not. But this is why, people got to be careful when they sue fire departments, municipalities. You better know the standards of proof and the defenses.
Yeah, and there's another defense, and that's interesting that you brought up the EMS related immunity. We got the workers' comp exclusivity immunity as well, which that's the first thing that came to my mind. So,
Yeah.
but usually, and I don't know if you researched the California law on this. I didn't. Some states have an exception that allows an employee to sue their employer for something that's work related,
I didn't even think
um,
about that.
if it's gross negligence or beyond something in it, something over and above negligence.
Right.
So, but again, it's going to fall into the same trap that you pointed out. They've got to allege something beyond that.
Yeah,
Yeah.
and if the defense is smart, see, this is how lawyering works. If they make the motion to dismiss now, they'll correct it,
Mhm.
right? But if they don't make a motion to dismiss, they just put it in the demur in the answer, and they just raise it, and the plaintiff doesn't catch it and do anything about it. And a lot of plaintiffs are like, "Oh, yeah, we don't care, we won't amend." If they don't move to amend, it could be too late later on.
Yeah, we
So
we have covered a case, I think it was 2 or 3 weeks ago, where that the court ruled that basically it's too late to amend. We're not going to allow you to amend to allege that, and the facts are the facts, and if the facts didn't bear it out in the first instance, why do they the same allegations bear it out in an
right.
amended complaint? Nothing has changed. So
Yeah, and for all I know, there's a case in California. I'm aware of some other ones that literally talk about intubation, where they say, look, you intubated, you didn't get it right, but you weren't grossly negligent, right? You at least attempted to act carefully by doing the intubation and by bagging. But you were negligent. And then you got public duty drive. You got a
yeah,
whole bunch of exceptions that fall into this.
yeah,
I don't know. I feel badly. Obviously, they lost a brother, and then they
yeah.
got to live with the fact that maybe they could have saved him if that's the facts. Maybe not.
And hopefully the folks that were personally involved in this incident, it's bad enough you're personally doing CPR on one of your brothers, and then on top of it, now the family looks like they're blaming you for
Yeah.
what happened, which is throwing salt on the wound.
When
So
I was running the ambulance in New Orleans at Tulane for the medical center, I had not one but two instances of our fellow, one our dispatcher who we worked with all the time. She had an asthma attack and was in cardiac arrest, and then we had a police officer dragged by a car who was a very good friend of ours. We're all a very close community.
Brad, you've had to do CPR on some really close people to you. I know
Oh
that.
yeah, my
I know
partner,
that.
right? I mean,
Yeah,
my business
yeah.
partner for 14
That's
years. And so
yeah,
I guess I bring that up because, to get then sued
right.
after that it's funny, I even forgot about that one.
Yeah,
But to get sued, I mean, people know it's tragic.
yeah.
So now you got to get sued and deal with that.
I know.
Um,
I know it. And
but
then 5, 6, 7 years, depositions, motions, this and that, and up and down and up and down.
and you
And
don't even get to grieve. You don't get to grieve because you're busy defending yourself on what you did, and yet you're distraught.
yeah,
Yeah. Anyway, I feel for everybody, obviously.
yep.
Okay, so maybe you want to pick this up. The DHS, the local governments, a number of local
Sure.
governments has sued DHS and FEMA over the new grant conditions. If you want to talk about that.
Yeah, I mean, it's a group of cities and towns in looks like California, Oregon, Washington, and Arizona. One in Arizona looks like, and they're alleging that some of the new grant conditions and is going to they're going to apply to all of the AFG and SAFER grants in particular, and also the fire prevention and safety grant program as well, in addition to some of the EMA related grant programs. So, but from the fire perspective, it's the AFG, primarily AFG, SAFER, and the fire prevention grants now have certain conditions. The lawsuit specifies three of them, and I'll read it from the blog so that I don't want to. This is a touchy issue for some, but grant recipients and subrecipients agree to and certify compliance with an interpretation of the anti-discrimination law that is contrary to statutory and decisional law. So, in other words, they're saying that the Trump administration's interpretation of discrimination law or anti-discrimination law is contrary to what they want to do. And how they interpret the statutes, how they interpret some of the cases. In other words, the Trump administration is downplaying DEI and basically saying, discrimination is prohibited, but that's going to be the end of it. And then the next one is the use of limited resources. There, as an obligation of accepting a grant, they've got to cooperate with ICE and other federal immigration enforcement activities. Apparently, they don't want to. They don't want to get on board with that. And then, they're concerned about what executive orders the president may be coming down with, and they don't want to be bound by that. So they're alleging that these requirements, these three requirements that they've singled out, should be struck down as vague, overbroad, or unlawful. So,
which is going to be very interesting. Now, I think they're mostly the blue states. I haven't gone one by one, but they're mostly blue states, I think, that were doing this, right?
yeah, I
California.
I don't think Arizona is, but I don't. It does seem certainly San Francisco, Los Angeles, San Diego, Oakland, Berkeley, Sacramento,
Yeah, California. I mean, right there.
San Jose. So um, Tucson, Arizona, I wouldn't think would be, but at any rate, they're but
We will see. Look, I mean, it's not uncommon to have conditions like if you accept an AFG grant, you got to have a drug-free workplace, right? I mean, so they have conditions in there all the time. Whether they're in accordance with the law, maybe that's a different issue, right? They're trying to put DEI back, and
yeah.
I don't know. It'll be interesting. Of course, they're going to very liberal courts. The Ninth Circuit is a very liberal circuit.
Yeah.
So
Yeah, no, for sure. And what we don't know, I mean, there's a tendency now for this case was filed in federal court for nationwide injunctions. And so what is the nationwide injunction going to do? Is it going to block all grants, all grant activity? Is it going to allow the grants to go forward, but just have a restraining order against the enforcement of those three issues? So it potentially can go beyond just those states.
right,
If again, particularly if you have an activist judge that wants to make a point, who knows where, how it can potentially gum up the works for other jurisdictions.
right. And before we get to the last two or three, because they're all kind of melded in, I want to bring up something that's happening tomorrow. It'll be very interesting to see what happens. The United States Supreme Court should be tomorrow, has a petition. It's called Petition for Cert, right? So for everybody's knowledge, that means we want somebody's applying to ask the Supreme Court to answer a question. And the question that's before the U.S. Supreme Court, I believe it's tomorrow, or we should have a decision tomorrow, is whether the Seventh Amendment, which is the right to a civil jury trial, applies to the states.
Now, is this something that you were personally involved in, or?
It is not my case. It's coming
Okay.
out of the Ninth Circuit. The Ninth Circuit, it's actually a marijuana case, but the Ninth Circuit said go ahead and make your submit your petition. So my brief is due in New York, as people may remember. We were the first case in the nation, I believe, that won that says the Seventh Amendment right is applicable to the states, which so everybody understands how big this is, because this isn't just a little New York court.
And let me kind of give
please.
everybody the big picture here to just, what we're talking about is, for example, if you're a paramedic or an EMT and the state is going to discipline you over something that could potentially take your license away, and particularly where that could cost you your fire department job. Or at least diminish your income, if you get a paramedic stipend, whatever it has. But the Seventh Amendment talks about the right to a civil jury trial. When government is going to take something, you have a right to a jury trial. And typically the way that states handle those discipline actions, they tend not to give you jury trial. In fact, they give you a hearing before. Sometimes it's a person called an administrative law judge. Sometimes it's just like a hearing officer. And there's very often no clear rules of evidence. And
the burden of proof is low.
And there's no avenue for you to get a jury trial. By the time it gets to court, it's merely reviewing the administrative decision, and you're out your paramedic license, and so on. So the issue here is whether the Seventh Amendment applies to those types of governmental decisions that could deprive you of your livelihood, particularly if you're a paramedic, and that you're not a firefighter paramedic, you're a paramedic, and basically without that, you're out of work. The state now has the ability to, without a jury trial, take your job away from you.
Right. And so the viewers may know I got a permanent injunction, meaning a permanent stop order against the state of New York from prosecuting a paramedic and EMT unless they give him a jury trial. The Attorney General's appealed that. My brief is due in 2 days. It's done. We're just waiting to see what happens to the Supreme Court. But the first question is, right, before we get to, do you get a jury trial in an administrative agency, does this Seventh Amendment even apply to the states, right? In other words, can the states violate the federal Constitution? And the first, second, third, fourth, fifth, sixth, eighth, right? All the amendments in the Bill of Rights, except for one, harboring soldiers in time of war, hasn't come up yet, right? But other than that one, every amendment applies to the states. And it was only in 2010 and more recently, and then there's another one coming up now with the Second Amendment where they said, hey, the states cannot violate your rights. It was against New York State. So we've been moving to a more full incorporation of the Bill of Rights. And if the Supreme Court takes this up, it's going to be like 6-3, 9-0, whatever it's going to be. But it is going to, I feel very confident that the Seventh Amendment, if they take the question up, is going to apply to the states. And then what's going to happen in every state, starting with my case in New York, then we're going to say, okay, fine, the Seventh Amendment applies, but before this agency, do you get a jury trial? And the test there is two things, whether they're trying to take something from you, either your money by fining you or your cert or your license or whatever. And then the second one is, are they pleading a common law cause of action, something that existed in the 17 and 1800s, like negligence, malpractice, professional misconduct, all existed back then, doctors, etc. There was malpractice back then. So this is going to change the fire department world, and not just for us, doctors, nurses. I think this is going to apply in discrimination cases. Before the EEOC already gives a jury trial federally, but states generally do not. Before divisions of human rights or those types of civil rights organizations, whatever. So this is going to be big. So keep an eye out tomorrow. I know you'll blog on it once we see what happens if they take it up. If they don't take it up, it's nothing bad. It just probably means my case will end up at the Supreme Court. So I've got mixed feelings, right? I mean, but for the betterment of the fire department, I hope the Supreme Court takes it up.
Well, I'm going to carry your briefcase on that one, so I'll be there with you. So.
Yeah, no, that'd be awesome. Okay, so, and then let's end with a couple black eyes. I mean, really black eyes to the fire service. And I don't even know where to start. Let's start in the FDNY, where there's two videos that show, I mean, you're kinder, you call it apparent hazing, but it appears to be hazing. And somebody decided to share it with the New York Daily News. So obviously somebody wasn't happy about it. One of them shows firefighters doing push-ups while repeatedly smashing their faces into cakes on the floor. I don't think that's so bad. I got to tell you that, to me, that's just kind of funny. And maybe we're too warped. But the second one is to show 3 uniformed rookies lined up against a wall on a paddleball court, awkwardly shaking hands and hugging 2 nude men wearing only shoes. That's weird and inappropriate. Shouldn't have happened. And
that's pathological. You know what I'm saying? I'm not sure where these folks are coming from, but
yeah, and but it's a good time for us to talk about must-have policies. The FDNY says, well, we have a hazing policy. Well, a policy on a shelf is a piece of paper on a shelf. It does nothing and it has no impact. So my question only is, are you teaching it? Have you mandated no hazing, no bullying, no harassing, right? I'm sure they talk about sexual harassment.
This is where policies come to collision with culture, and they have a long-standing tradition of doing this kind of hazing to rookies. And sometimes some stations are a little bit more over the top than others, but This is, it's like the frat house culture. And, fortunately, my department, we never had anything anywhere close to this kind of nonsense.
Right.
But, I don't know. The
We did
officers,
stupid
the
things.
officers have got to get their arms around this and figure it out and get it to stop.
Yeah.
This does nothing to improve the fire department. This is
Yeah. And God
ridiculous.
forbid they were women, right, who were the recruits there too. But anyway, it's a black eye. And then because it never stops, we get 2 firefighters in Maryland who've now been charged criminally with causing tens of thousands of dollars to a baseball field because they were pissed off due to allegedly repeated incidents involving baseballs striking personal vehicles, the fire station, and department equipment. So what do? They allegedly take their matter in their own hands and flood the baseball fields.
What were they thinking?
They weren't.
Yeah,
I don't know. There's a lot of just bad seeds, and that was bad judgment.
Bad judgment, man. That kind of bad judgment is usually associated with off-duty alcohol. That is mind blowing that they're using the fire trucks to flood a baseball field. That's just.
Yeah, and presumably there was an officer with them, a lieutenant, captain, something who, or maybe they just said we're going out training, but it doesn't take a lot, right? A water cannon can flow 750 to 1,000 gallons a minute. You're connected to a hydrant, you'll flood that field in no time, and you will ruin it.
Yeah.
No. Anyway, that's it for today. And
we got
I
one
hope
more. We got
yeah.
Waterbury.
Yeah.
Waterbury had a cheating scandal.
Oh yeah, I skipped that. I'm sorry. Can you do that?
The whole thing. Apparently, they had a 13 member
Recruit
class, and seven of them ended up resigning over some sort of a cheating. They were looking up answers to the questions on computers and cell phones during a supposedly proctored, I guess I'd say a poorly proctored test.
And 6 were cleared, right? I think half were cleared of the wrongdoing.
Yeah, I guess some of them did not participate in it. Some of them did, but they did discipline 2 of the, and there was a mixture of news articles out there. Some said 6 resigned, some said 7 had resigned. So I'm not sure the exact number, but 2 of the members who did not resign, who were kept their jobs, were given an extended probation because apparently whether they weren't honest about it or they didn't report it. But that again, that's
we can do better. I think we can do better. The fire service can do better.
And I mean, unless they were ignoring the proctor and the proctor was telling them stop it, and they were ignoring it. If the proctor was allowing this, I'm not saying they should be cheating. I'm not.
Right,
but I'll tell you what, nobody's cheating when I'm proctoring an exam.
Yeah. So begs the question, what was the proctor, if they were present, what were they doing?
Before we're terminating somebody, for something, I think I would be looking at, let's do some sort of a retest here. And there'll be consequences, but I don't know. I don't know how something like that happens if the exam is being properly proctored.
Right.
So,
right.
But at any rate.
Well, with those 3 black eyes.
Really.
Let's hope we get back to some good lawsuits next time.
Be good this week.
Yeah. You don't want to be on our show. No, sometimes you do. I don't know.
That's it. So, all right. Well, that's going to do it for another.